What's up, everybody? Good morning. Saturday morning here, last day of the trip. It's been really fun. It's been long. It's been a little bit of work. It's been a little bit of fun, but overall, it's been a pretty awesome trip. And I appreciate everybody that's been joining me on these random lives that we're doing at different times. I was not able to do it last night. I was kind of unplugged a little bit last night. I did not watch the entirety of the hearing. I have seen clips and bits and pieces of it. So I've been saving a lot of my thoughts for this video so we could watch it together. I could answer your questions. I did see a lot of questions on Twitter, so I will work the answers to as many of those questions in as we watch the video. And then, of course, I'm sure you all will reiterate a lot of them because you'd be surprised how many questions get asked multiple times, which is why I always say if you have a question, ask it because you're probably not the only one with that question. So we're going to talk about this. Now, I did see some clips of Shannon Gray, the attorney for the Gonsalves family, and I have a lot of thoughts about what he said, how he said it, examples and illustrations that he used, whether or not I agree with kind of his point, and then kind of the way and reasons he did it, maybe. So we're going to talk about that as well. And you guys will drive the conversation at the end, as usual. And again, because it's so early and because we didn't post it ahead of time, I do expect the crowd to be a little bit smaller, which is fine and actually gives you more opportunities for the questions to be seen. But also because of all of that, I'm on my own. So I wanted to get it out and get it done as quickly as I could from when the hearing happened while it's still fresh for everybody and not wait until next week. So I will try to catch as many of the comments and questions as I can, but I am also going to be listening pretty closely to the hearing since this will be me watching it for the first time with all of you. And with that being said, if you guys would hit that like button, it'll push it out to everybody that may be interested in this content, and we can all watch it together. Also, because I haven't watched it and because the sound isn't great, we are not going to bump it all the way up to 1.5 speed. I might just do 1.25 speed. You know, we like to keep it efficient, but the sound quality is not the best either. I think Law and Crimes is better than Court TV's. I'm sure somebody will disagree with me. But I just kind of clicked through to listen to the sound. So this is when he's about to go on the record. We're going to listen to it together, pause it, react. Hopefully, if you've already seen the whole thing or you don't get annoyed at this point, everybody knows here, we're going to be stopping it. We're going to be discussing as we go through the hearing. So let's get to it.
Okay, so let's get on the record, please. We are now on the record. This is State versus Brian Koberger, CR 29222805. We're here for a hearing on the Gonsalves family's motion to appeal, amend, and/or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine. They did. And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. Koberger is in the courtroom, represented by Ms. Taylor and Mr. Logston. And I believe Mr. Gray is there. He is.
Let me sit back here, Your Honor.
And I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Gonsalves family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families.
So that's interesting. I didn't catch that part on any of the clips that I've seen. So he starts out by saying his heart goes out to the families. And I think it would be remiss if we did not mention and compare to the Parkland shooter case and how the judge, hugged the victims at the end. Her heart obviously went out to the victims as all of ours did. There is nothing wrong with this. There's nothing wrong with judges caring and being people and their hearts going out to victims' families, especially victims of a horrible crime like this, to young children, kids of parents and college-age kids. And that does not mean he thinks Brian Koberger did it. Now, there's a little bit of a different context when the defendant has already pled guilty, right? Because we know who did it. He's admitting who did it. So it is a little bit of a different context, which is why it's probably better just to wait till the end and not do it like right now in the beginning. But in this case, totally appropriate. No issues with it. No issues with the way he did it right here. He's not going overboard. He's not saying, let's, crucify that guy in that chair because he obviously did this. That would be problematic. And again, showing no favoritism by saying something to the victims and their families, showing no favoritism between the lawyers or the sides, the prosecution and the defense. So just figured I would mention it and not just let it slide by.
The loss to your children is devastating and horrific. There's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of names, Haley's name and Zing's name, and I want to explain that. I was up all night.
So he is apologizing for mispronouncing their names, which a lot of you caught. We talked about. We said we'll give him grace. You never know what is going on, and a lot of pressure maybe. Let's see what he says.
Really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology.
So let me just tell you real quick. So he says he had food poisoning, wasn't feeling good, was up all night, not at his full potential, regardless of what the reason was for it. I know a lot of lawyers. I know a lot of judges. The judges who would do what he just did and acknowledge a mistake and apologize for it, whether they give a reason for it or not, but sincerely apologize in open court on the record with cameras on for everyone to see and always remember that he made this mistake and mispronounced these names, shows the utmost humility you can have for someone who is king of the courtroom. He did not have to do this. I would not have blamed him if he did not apologize. Some people may have felt some type of way about it. I would not, because I understand how it is. And there are some judges that, and some lawyers and just some people in general, I'm sure that you know, that never want to admit they ever make a mistake, especially one that can be recorded and everybody can point back to, God forbid something happens in the future. But at this point, he doesn't care about any of that. He cares about apologizing to the victims, making sure that they knew it was not because he does not care. And it was not that he was not prepared. And it was not that he just, it just doesn't matter to him and he's aloof to everything going on in his courtroom. So major props for that. Major props for that.
I know some people were concerned about that and wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Koberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Koberger's right. And under Rule 11A1 of the Idaho Criminal Rules, and this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom. And that's important for journalists. That's also important for the citizens. So if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website. And it's very, very easy to read them and maybe get a better understanding. All right.
So, and yes, I know I was muted. I was actually talking to Maverick in the middle of the video. That's why I was muted. But so basically he explained that that's something that's totally appropriate. The judge has to enter a plea when he doesn't enter a plea or stand silent, whatever you'd like to call that procedure. And it is a nothing burger basically, but he didn't really tell us the reason for Brian Koberger doing that. He didn't really tell us that Brian Koberger did that because of the media. He didn't really tell us Brian Koberger did that because of some plea deal. He just basically said, you shouldn't speculate on it. It's a totally appropriate plea. They can plead guilty, they can plead not guilty, or they can not plead. And then the court has to enter a not guilty plea, which we all already knew. We looked it up. We talked about it, but it is still a decision. You have three choices, and that's what they are. You make a choice. You can plead guilty, not guilty, or stand silent. I don't care what anybody tells me. I've represented clients before. I've made these decisions with clients before. The clients make a choice, sometimes on advice of counsel. Sometimes they understand the process enough to make the choice on their own. And in this case, he made a choice. But there was a lot of rampant speculation going on in the media. So I am appreciative that the judge did also explain this, which is why, I mean, we're going to talk about cameras in the courtroom, for the next few weeks. But this is why I think it's important to have cameras in the courtroom. The judge can take the opportunity on the record with the cameras on to correct anything that's going wrong in the media, or to try and discuss issues that he thinks are important and significant that may be misleading in the media. You can do a lot of correcting with open communication, which is, I don't want to say I do a lot of correcting. That was a bad thing to follow up with, but that's one of the points of this channel, is to discuss stuff so that you guys can understand it as the public, as potential jurors, as people that are watching this trial and other trials, so you can understand it better. And I think cameras in the actual courtroom coming from the judge's bench, I think that's a major benefit to having cameras in the courtroom.
All right, so that's my speech for today. Mr. Gray, come on up.
All right, here we go. Now we get to hear from Shannon Gray, victims Gonzalez
And-
family lawyer.
If you allow me just a minute or two to get sorted out here.
Take your time.
Thank you.
Thank you, Mr. Gray.
May I proceed, Your Honor?
Yes. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that hard thought. Thank you. I first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall ordered submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6.
All right, I'm going to pause it for a second because I did get this question or comments about his shoes a bunch on Twitter. And some people even sent the meme where there's a lawyer with baggy pants on and, dirty shoes or whatever. It's like, this guy represents you, you're going to prison or something like that. This is how your lawyer dresses, you're going to prison. So a couple comments that I have. Number one, they're not sneakers. They're not, some kind of not dress shoe type of deal. They are not a loafer or a lace up or a wingtip or, some kind of normal dress shoe that is worn with a suit in court, but they are kind of Cole Haan type of shoes that are still recognized as dress shoes. And I will say more and more people do wear these to court, to hearings, things like that. A lot goes into thinking about it when you're a lawyer and you're coming up in front of a jury. You don't want to dress too nice, but not nice enough. You want to come somewhere right in the middle. You don't want to wear your most expensive watch and make them think, oh, this guy's some kind of snake oil salesman. But you don't want to come showing up looking like, your suit has holes in it and things like that. Like they expect a lawyer to look a certain way. We've talked about that in other streams. I will say I almost never comment or disparage anybody for what they look like or how they dress. I think when we talk about lawyers, you have to look professional. And if they don't look professional, then I would say I think that that's a mistake. You should look professional. When it comes to footwear, I actually do know some lawyers that wear sneaker type shoes to court. And some people, as you just know, as you go through life, have feet problems, back problems, knee problems, and certain shoes they just can't wear, including dress shoes sometimes. So I don't know if that's one of the reasons he picks Cole Haans. They're definitely more comfortable than most nice dress shoes. So that could be a reason, or it's just a more relaxed thing. It's a hearing. It's not in front of a jury. So he wears a little bit more of a relaxed pair of shoes, or this could just be his MO, which I don't think anybody or any judge or any jury would really think was inappropriate. I could be wrong about that because a lot of people commented about his shoes. But from my perspective, I see no issue with it. I don't think it looks sloppy at all. And I see a lot of lawyers wearing this type of shoe. If you're asking me personally, I don't. I wear, nice dress shoes with a suit whenever I wear a suit, which is only when I go to court. Basically now, I used to wear suits all the time. Now I try not to wear them unless I'm going to court. I love wearing a suit. But in Florida, it can be very annoying, especially in the summer, because I'm dripping with sweat walking from my office to my car. But those are my thoughts on his shoes.
As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested a transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we can have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom, where they take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties abstracted above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have the responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as, if I had known that we were going to be discussing the Idaho Rules of Professional Conduct in that issue, I would have prepared, but only having a 3-hour notice to allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now,
and while some people will call that a gripe, that's fair. Literally every lawyer will do that. We've seen extensions of time asked for in this case multiple times, other cases as well. If you're not on notice what you're going to be arguing, and then they change it and say, oh, we're going to be basing it off this rule, and you only have 3 hours notice. Now, 3 hours, you could probably do some research. But if you had another client or another hearing or another meeting or whatever, and you didn't have time to do that, then it is not fair to expect a lawyer to argue something like that, which is why we have deadlines and response periods, 30 days for this, 5 days for a response, 10 days to set a hearing. All of those are in place so that lawyers can be prepared. Lawyers are not supposed to have everything memorized, right? Like every question you ask a lawyer, even if it's something they specialize in, they're not supposed to have everything memorized. We have resources we can go through, and with experience and knowledge and what we've done and what we know about other cases, we can do research, connect things, cross-reference things, and then we come up with what the correct answer is. Not everything just comes off the top of our head. So that's a fair explanation.
After the non-dissemination order in January 3rd and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case or any attorneys that might have an interested party in this case.
We did talk about how the amended non-dissemination order almost seemed like it was pointing specifically at Shannon Gray, but it added more lawyers to anybody interested in it, to anybody that could possibly be involved in the case or represent somebody involved in the case. I think that was the reason for the amended non-dissemination order.
So that's where we are today. I filed a motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all the case law.
Correct. He's correct.
As well as.
Can I interrupt you?
Yes.
There's no dispute about that.
Okay.
Your clients are not parties. The only parties of this case are the state and Mr. Koberger. That's clear. That's clear in the case law with regard to any victims or victims' families.
So Lisa, any interested parties? Why? So I think they're going to get into this again. I have not watched the whole thing, but usually the reason why you keep any interested parties out is just like we had Andrew Crawford, one of Johnny Depp's lawyers, on yesterday. It was a really fun conversation, really good dude. But when he says something about what they were doing during trial, it's legitimate. You can take it to the bank. If I say something, I'm just talking about what it looks like, comparing it to what I do in my experience, guessing, pontificating, speculating. We're just talking about this stuff, using our experience to explain it. But when it comes from, as they say, the horse's mouth, there is a difference. So any interested party could have more information, background information, see behind the curtain, and let that get out. It is a bit of a different vibe. And I think the audience takes it a different way than, Emily Baker explaining it. Emily Baker's explaining it from somebody who's been a prosecutor with her experience. And this is why this happens at a hearing. This is why a judge explains this way. And when you hear all that, you're thinking, oh, okay, cool. But you don't think that's exactly what's happening in this case. And if Shannon Gray says, this is what the cops told us, or this is what the cops found, well, you can take that with a bullet because he is interested or involved in the case and could have more information. That's what I expect to kind of come out during this hearing of why there is that difference between, Shannon Gray and Emily Baker. Let's just say if both of them go on court TV and give an interview, you're going to look at them differently.
There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
So let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tap case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezerov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Varner versus Delahanty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Sloth was a defense attorney. Irwin versus Dowd were the prosecutor's actions and speaking to the media. Shepard v. Marshall, Maxwell is the trial publicity regarding the prosecutor's actions prior to trial.
This is what lawyers do, just to point out what he's doing. He's saying in all the other cases where a non-dissemination order like this was appropriate, they were all directed at an attorney representing a party, either the prosecutor or a defense attorney, not a victim family lawyer. So this is how you help judges make decisions. The simplest way is, look, judge, all these other cases and all these other judges decided that this was the right answer and you should agree with them. You should pick the same answer that they picked. It would convince any of us, right? It's like, if you're a dad, it's like all dads think this is the best way. It doesn't mean you have to do it that way, but you may think twice if you're going to go against every other dad that's ever made this decision, right?
None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me because I'm not involved in the litigation. She also says that.
Can I ask you a question about that? Because I think case law.
By the way, this is also, I like this format. Okay. So in law school, there were two extracurriculars I was a part of, right? Mock trial, which you all guys all get what that is. We basically did fake trials, fake juries, fake judges, fake witnesses, whatever, real law students pretending to be lawyers. But then there was also moot court. And what moot court is like fake appeals. So what we would do is we'd get an issue. We would do all the research. We would write a brief. And then we would go in front of a panel of real judges and they would fire questions at us. And when they would pipe in and ask a question, that's how you would know this is something that's important to them. And when Judge interrupts Shannon Gray, you can tell this is something that is important to Judge. He wants to get this answer because it's going to help him and make his answer, or he is trying to, through his questions, explain to Shannon Gray why he's wrong, or explain to the other side why they're wrong, whatever lawyer gets up there. So that's kind of a cue from the judge. When they start asking questions, you're going to get their opinion in their questions. So it's important to keep an eye out for that. And that's why lawyers have to do all this research. And you may have 100 cases you've researched, but you're only going to reference 2 or 3 unless a judge asks a question. You want to have more cases to answer that judge's questions. Because if the judge says, well, isn't it true that this happened? She's like, no, judge, in these 3 cases, this is what it said. That's how you kind of respond to a judge, which in real life, I'm not a big fan of appeals. But moot court and in hearings, which are like mini oral arguments, I love it.
It's quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm
That's basically what I was saying before. So no surprise, no genius work by me. That just is obviously, that's why it makes sense. Any interested parties.
recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the.
If your clients are witnesses potentially, it's like they're not are witnesses. It's either they're potentially witnesses, right, or they are. And at this point, they're not, is what it sounds like. But they are potentially witnesses. I don't know what the Gonsalves family could possibly testify about that would be relevant to the case. Their daughter's character and how amazing she was, that's probably not going to come in to this case, because why is that relevant to whether or not Brian Kohberger did this? Now, as part of sentencing, potentially it could come in. But I think there's an argument that sentencing is completely different from the actual guilt phase. And we're not as worried about, because that stuff can already come out about how great she is and everybody can report on. There's nothing wrong with it. That could come out in sentencing. It's not like they're going to have facts that they're going to testify to that could poison the jury pool. So it is interesting on, are they witnesses or are they not? And just to hold it open that they're potentially witnesses in order to keep them under a gag order, I don't think is very fair.
And I can address it, Your Honor.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Kohberger was indicted.
To me, that's shots fired. They've never been involved in this investigation, meaning they won't tell us what's going on. They won't involve us. We wish we were involved and they won't involve us. So it's like they're having their cake and eating it too, calling us potential witnesses to shut us up, but then not actually keeping us in the loop and giving us any information that the public doesn't have.
We received no information about anything regarding the prosecution. Nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger. They told us that there was a grand jury that was being impaneled. And common sense, we figured it out because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical.
So based on the other interviews, I thought that they did tell them Kohberger was going to the grand jury. Now they just kind of insinuated that there is a grand jury. It may or may not be Kohberger, and they put 2 and 2 together, which I don't find unfair by the state. I think that's totally fine by the state. They said it without saying it. They're trying to be careful.
The critical part of it is that the prosecution has never, ever interviewed the Gonsalves family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not getting witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was their grandparents.
So we remember this because we covered this, and that's what makes this stuff fun. As we go on and we build a history of handling these cases, especially in Idaho. Never thought I'd be talking about a case in Idaho, but when he argued the Woodcocks and one of them was immediate family, one of them was not. And again, he is leaning on that same state. Judge made the call. And in this case, the victim's family should not be party. I also think that because the state has never interviewed them, they went through the investigation. They got the probable cause affidavit. They made the arrest. They prepped for the preliminary hearing. They prepped for the grand jury. They presented evidence for the grand jury. They're preparing for trial that's going to happen in a few months. Never interviewed this family, yet you're still saying they could be witnesses? Come on. Here's an easy answer. They're not witnesses until they are. And when they are and you share information, you can ask them, do you want us to share this information? Do you want to potentially be witnesses? Because if you are, sign this and you're under the gag order now. But until then, they shouldn't be under the gag order. That's the court of common sense here for Peter Tragos, but I'm not a judge. But I mean, this does not seem hard. Calling somebody potentially a witness just to step on their First Amendment rights potentially, I don't love it. I don't love it. John, at this point, this case is so large. Isn't more info related the best idea? It's a mixed bag, right? I can find positives on both sides, but I do think it's a little bit weird that they're trying to silence this one guy. And again, I also think it's a fair criticism because I got this on Twitter as well. This guy wants his moment in the spotlight. You know, he wants to have his cake and eat it too. He wants to represent the victims, but he also wants to do what you're doing, pointing to me and talk about this case online or go do media reports or whatever. And I think it's fair. It does kind of sound like that at points, but I think he's right so far. And again, there's going to be more argument to come that it doesn't make sense to have them under the gag order as potential witnesses, but then give them no, because they might have information that they can leak, and then give them no information, not interview them and not use them as witnesses. They're just kind of in this vacuum by themselves where nobody else is. Josie, Peter, given the parents of Kaylee are giving interviews while they aren't held to the gag order, doesn't it help the defense regarding change of venue? I mean, all of this is going to be helping the defense potentially if they do want to change venue, but is a change of venue going to help? I don't really know if a change of venue is going to help them either, depending on where they change the venue to. But theoretically, anything that happens in the media, anything that could potentially bias a jury pool is going to help with change of venue. So theoretically, yes.
Completely different statutes because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, they never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potential. That's not good enough to stop the free speech of the victim's family, as well as myself. The other thing is that if the victims can say whatever they want, free speech, and that's exempt, why would I not be allowed to say the same thing that they say?
My understanding is that your clients are not restricted in any way, never have been.
Well, I'll give you an example.
I think it's not true.
That's right. Well, I agree now, because that's not the tone of the Zoom meeting.
Well, we're not talking about the tone. I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I ask for clarification, now I understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But
So I heard that this comment was coming, and just a quick point on it. So he's giving an example saying, do we think the judge is crazy? And he says, I would advise against that. The judge says, thank you. Not the example I'd use. Maybe I'd say the prosecutor, right? Especially if I've already got beef with them. Maybe I say, they think the prosecutor's crazy. I would advise against that. I'm not bringing the judge as crazy into an argument I'm trying to get the judge to rule in my favor on, okay? Because regardless of whether or not you joke about it, I don't know if they have a relationship, it may be different. I don't mean an improper relationship. I just mean I'm friends with a lot of judges. They don't just do what I say when I walk in the courtroom, okay? As most judges don't. But if you have a friendly relationship, they're not going to take offense to this. But subconsciously, if somebody's saying 15 times, I heard he says it in the hearing, that the judge is crazy, there's something about me being like, maybe they do think I'm crazy. I don't know. DS, did they keep the gag order? He's reserved ruling on everything, basically, which is not uncommon, especially with these kind of arguments. Victoria, I think some judges want his or her courtroom / trial to be done the way to be what they want. You're not wrong. And it's not, you're only wrong about one thing. It's not some judges. Every judge wants it done the way they want it done. But it is a case-by-case basis. It's not always exactly the same, especially when you have a case of this with this public interest.
if I went and said, the family asked, has said that they think the judge is crazy. There's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer my own opinion, right? Well, then I'm already governed by the Idaho rules of professional conduct. And if
I'm glad you're acknowledging that.
no, well, every attorney is, Your Honor. I mean, it's not you.
Oh, okay. That was a bit of a subtle. I'm glad you're acknowledging that. As if like maybe the judge was like, I wasn't sure you knew that, Mr. Gray. I don't know. That I did not expect him to say something like that. But I mean, that's the point. We're all talking about it. As I'm sitting here, we're all under the rules of professional conduct, and we have to be ethical. And he's right. Regardless of what the gag order says, even if he is allowed to speak, which I think is what he's getting at, even if I am allowed to speak, I am still governed by those rules. So you don't need to put this gag order above and beyond.
Every attorney is. So I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe go troublability. But the troublability I don't even think applies to me in this anyway, because if you look at it, it says it applies to a lawyer who is participating or is participating in the investigation or litigation of a matter, shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall. Then in paragraph 3, the rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this: rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea what it is.
You've been on the media and you've had interviews. So I'm kind of wondering how do you feel that you've been restrained?
Oh, interesting. So this is going to be even more interesting. I heard that it was contentious, but he's like, you've already been doing interviews, Mr. Gray. How have you been restricted? What do you want to say? What do you want to say so bad? Maybe he's like, I don't know about baiting him, but say it in open court right here. Cameras are here. What do you want to say? You want to say you think he did it? What do you want to say? Interesting. That's really, really interesting. Sonia, Peter, thank you for what you do. Do you think there will be cameras? And also, do you think they will be sequestered? I think as each case kind of goes, things are building in a certain direction. Based on the way this judge has tipped his hands, I kind of feel like cameras will not be in the courtroom. But I think this judge also said that he's never not allowed cameras in the courtroom. So that gives us maybe a little glimmer that he may go against where it's leaning right now and allow cameras. I think the fact of what happened with the Valo Daybell case, and I think there was a little bit less interest because of the cameras, but not a ton, because of no cameras, I should say. So that's where I would lean right now is no cameras. Will they be sequestered? It's too early for that. But I don't think it's out of the question. But that is next level. Like no cameras will definitely happen before sequestering a jury, because that's really, really rough on a jury who's volunteering their time to do their civic duty.
Anyway, with this order,
I think you're not seeing what the point is. But the point is that the court has issued a non-dissemination order that restricts First Amendment rights.
He's like, that's besides the point, Judge. What I haven't been able to say that I want to, which is a fair argument, right? The point is, you don't have to ask every time you want to say something specific. The point is, why are we trampling on rights if we don't need to? We don't need to unnecessarily trample on rights. Same argument was made in the Petito laundry case, where the judge was asked, like, can we do confidentiality? He's like, why? Explain to me why we need confidentiality. Why do I need to be hampered for no reason? If there's a reason, let's talk about it, but there's not.
Overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process?
I don't know if the court would say yes to that. I think they should. Any lawyer knows it's difficult for any layperson to go through anything like this. I'm representing a few clients right now who are going through, there's a criminal process with what I'm representing them on the civil side. And I will just tell you, conversations change when victims push back at all. We're all here for you. We feel so bad. We're sorry. And it always happens. If the victims push back, now some victims don't push back at all. They just say, whatever you want to do, do whatever you want to do. That's fine. But if they push back, if they ask for more, most of the time the state is not, they make it clear they don't represent the victim's best interests or wishes. I'll just say that. So it's not unusual that sometimes, tensions can run high because especially when there's loss of life or serious injury, nothing's ever going to feel like enough. So I think it is good for a lawyer to be there to explain this process to the victims' families. And just from my experience, being able to do it on all three sides of this, I think judges should absolutely want that. And I think it is a good thing. And I think it could help keep the victims' families from going out there and poisoning the jury pool or limiting the jury pool. So I think there are a lot of benefits, as we talked about right when Shannon Gray, I don't know Shannon Gray, but right when he jumped on this case, there is a lot of good a lawyer can do to help victims through this criminal process.
Would the court encourage that they could explain things, say, maybe advise them on what to say, what not to say? If you're taking my voice away, you're taking the voice away of everything. The other part of it is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family.
Ooh, so this is something I heard was coming. He has not seen in 22 years of practice a poorer line of communication. So if we just step back in our time machine a little bit and we remember early on, right when Gray got on the case, I was in North Carolina doing videos on this, and they were critical of the investigation of law enforcement. And then once an arrest was made and the probable cause affidavit came out and we saw some of the evidence that law enforcement had, they kind of backtracked a little bit. We're on the same team. We didn't mean to say anything, bad about investigators, blah, blah, blah. We want to be involved in this process. Well, now it seems they're not getting as much information as they want, and it kind of came back. And it's like a ebb and flow as it goes throughout the process. But at this point, it seems like some lines are being drawn in the sand, and Shannon Gray and the Gonsalves family are feeling like they are not being involved like they think they should be, kind of back to the beginning of the investigation, and they're calling it out. He's never seen a poor line of communication. And let's not forget, just in the back of our heads, that they did file their notice of claim, which they had to file to potentially preserve any civil lawsuit that they may file against law enforcement, against any of the sovereign bodies or establishments that have been involved in this case. Just keep that in the back of our mind, because I don't think law enforcement or the state attorney's office appreciated that either. But again, a lawyer has to say, listen, you may not like us, but I'm protecting my client's rights. Period. That's it.
And I think it stems from, initially, we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they never ever interviewed them in any way. It's just an attempt to shut the attorney up and shut the family up, is what it is. Because
he's not pulling any punches. It's just his attempt to shut us up.
If I come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know what's in all the investigation, obviously, and a lot of us don't know and probably won't know until the trial. Okay, well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in that process of sentencing. That is not post-conviction, technically, is it?
it's if your goal is fair and impartial jury, right? That's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process. So I have that job. I have a job of.
I kind of disagree. So I did hear this argument being made. I kind of disagree that the penalty phase really would make a difference. I kind of mentioned that off the top. I get what the judge is saying. They could still be witnesses in the penalty phase. But I really like this judge too. Somebody said I'm warming up to this judge. I like this judge. I think he knows what he's going to do. But I do kind of disagree with him because once he's convicted, I think that even with the penalty phase, I'm not sure how them going in front of the media, family saying whatever, attorney saying whatever, these aren't facts that you're coloring the jury on. Most of the penalty phase is going to be on mitigating and aggravating factors. And it's going to be, the mental makeup of if Brian Koberger gets convicted, okay. Just like the Parkland shooter case, it's going to be about his mental makeup. Was he abused? Why did he do this? Should we have mercy on him? So I'm not really sure how this gag order, keeps stuff from getting to the media, because they're not going to share his, medical records or mental health records with the victims' families. All the victims' families are really going to talk about is how sad they are, which they've already talked about. So I don't really know. I don't think I agree. Monica, why was the judge watching this case on the media? He's allowed to. And frankly, because he's making these decisions, I think it's important for him to watch. What are the YouTube channels talking about? What are the media channels talking about? And see if the media attorneys, the defense attorneys, Gray, the prosecutors, if what they're saying is accurate based on his consumption of the media and what the media is saying about this case. I don't think there's anything wrong with that. I think, frankly, in this case, he's being almost asked to look at how the media is talking about this case and making his decisions about cameras and the gag order. Time. Change of venue in Idaho, population 2 million would not help. I'm in Louisiana and follow this trial. Yeah, I'm not so sure I disagree with you.
Protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. In this hearing is about.
And as an officer of the court, I can tell you we have zero access.
Okay, so you're saying that the prosecutor's office has not shared information with your client
regarding the facts of this case? No, they haven't.
So you could see Thompson kind of moving in his chair. They have not. With the facts of this case, they have not. That's a big statement. The prosecutor's office has not shared. And it seems like the judge thought the answer to that question was going to be yes, they have shared some stuff with us. But Shannon Gray did not hesitate and said, no, they did not.
Right.
How things occur.
Everybody's going to have a chance to weigh in on this. And I just, you're helping me understand what the issues are. So thank you.
You can see the judge's eye go over to Thompson, because I think Thompson's probably shaking his head.
So that's really the issue here. I mean, and this is an important ruling, because what you're doing is this has never happened before, ever has it happened before, that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened that I'm aware of.
Would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to do that.
Well, I think I do have the authority.
Well, my argument is that part of the argument is that.
In fact, I know I have the authority to do that.
Well,
okay, so the judge is getting a little annoyed now. It was all jokey, fun. And then as soon as he said you don't have the authority to do that, which people ask me, is that an appropriate thing to say to a judge? I think it is if it's legitimate. And as someone who works on civil rules, there are things that say judges must or shall do certain things, and then they may or have discretion to do certain things. And if it's a must or shall, and they're going against that must or shall, I think it's okay to call them and point them to the language that says, this is what you have to do. You do not have discretion here, judge. You must do this. That's a totally appropriate argument. If you're not sure about it, I would not say it to a judge. Sounds like the judge did not love that. And kind of responded with, oh, I'm sure I have the authority to do that. I also want to point out that the judge, based on this question, I think would like to find some compromise and maybe say, yes, Mr. Gray, you can talk to the media, but you can say this, you can't say this. I think he's looking for something like that, which I think is a good thing. Anytime a judge is looking for compromise, I like that. In these situations, I should say.
And the authority would be through the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay,
that's
hard to accept. But
we're not witnesses in the case. We're not involved in the investigation. We're not involved in the litigation.
I think Gray might be right about the fact that they're not involved in the case. They have an interest in the outcome and they want to see justice, but are they involved in the case? If they're not getting shared information, if they're not being interviewed, if they're not being witnesses, if they're not helping either side, I mean, they want one side to, I don't even know. I think he could argue, we're not even saying we want the prosecution to win. We want the right person to be convicted. We don't know if the right person is Brian Koberger. we believe there's probable cause and that it's probably him. But I mean, I think that's fair for him to, I get what the judge means. Like, that's hard to hear or hard to accept that you're not involved in the case as the victim's families, but
I can't file any motions. I can't subpoena anybody. I can't cross-examine witnesses. I can't do anything. So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is.
We're talking about your
That's right.
speech.
That's
not
right.
your client's speech.
But that is part of it, though.
All right, so there you go. There you have a little bit more of an indication. The judge smirks a little bit when he says we're talking about your speech, not your client's speech, your speech.
Well, in your memorandum, you are suggesting that you also have an independent position, that you are representing yourself.
I do.
It's distinctive from your responsibility to your clients.
So this is where people were saying, you know, he wants to have his cake and eat it too. He wants to represent the victims' families and actually be the attorney on the case, and then also do what I'm doing, right? And just be able to talk about the case as himself and not as the victim's attorney. He has his own First Amendment rights. I don't know. That'll be interesting. Yeah, 3,500 people joining us on a Saturday morning. I love it. You guys always show out. Hit that like button. Let's get to 3,000 likes here in the middle of this. And also subscribe, because we are almost at 240,000 subscribers. We could hit 240 by the end of this video if everybody who's watching subscribes. So hit that subscribe button, please. Brooklyn Basement asks, why was he in prison clothes until yesterday? The court let him wear a suit. The defense can ask for it anytime. Judge can allow it. I think, again, if you want my guess here is that there's all this talk about media attention. There's going to be cameras in the courtroom. At this point, Judge, we don't want to poison any more potential jurors. Let us put him in a suit. Everybody's commenting about how he looks and how he's standing and how he's acting and his facial expressions, his clenched jaws, and how he looks as attorney if he cracks a smile. Let us put him in a suit. Let him look like an everyday person, sit there. But of course, people are talking about that, which is fine. I get it. People are going to have questions about everything. I don't have a problem with that. But I don't want to go overboard on what we see, because that's why we can't have nice things and why they're going to pull cameras, which is not what you're doing at all, Brooklyn Basement. I know that. I'm just connecting dots here. But yeah, I think it's totally appropriate for him to wear a suit. The judge allowed it. Defense probably asked for it. And it probably had a lot to do with the media coverage, the cameras, everything they're talking about today. If they can try to prevent everybody from convicting him in the court of public opinion before he's had his day in real court, then the judge is probably going to allow that. Again, protecting a fair trial here.
That's why the motion is for amending or clarification, because there's clients that have the freedom to speak. There's me repeating what they have to say. If they said the judge, we thought the judge was crazy, and I said the judge was crazy, I can't be, that doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice, where I said the judge is crazy. Yeah, I think the judge is crazy. That goes into another way, right? Where it would be, Idaho rules of professional conduct would fall into play, what I would be doing or what I couldn't do. Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, extradited those statements. And I may or may not fall under the probability. I would argue that I don't, because I'm not a party to it. I'm not litigated it. I don't have any information on it. None of those things. So really, that's where the authority for me, for my voice, would come from the Idaho rules of professional conduct, if I did that. And if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for you, for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is on an Idaho bar member, is walking down the street, looks up, sees a television program where the Gonzalez family says, well, we thought the judge was crazy, right? And then all of a sudden, the media is outside, they interview him, they say, hey, you're an attorney here. What about the judge being crazy? Well, I've been in front of him 3 or 4 times, and I would agree with him. You're going to sanction him and contempt of court? You can't. Same as me, because I'm not a party to it. He's not a party to it. He might be governed by the Idaho rules of professional conduct.
So that is making sense now why people were asking me that question. It seems like maybe he just wants to comment on the case, and do videos like this and break things down and what's going on and what he thinks and based on his experience as an attorney here. And if they're not a party to the case and they're not involved in the case and he's not representing any witnesses, he should be allowed to.
By commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because.
So the only thing I'll say here real quick here to Tori's comment is I don't think there's anything wrong if we want to comment on the clothes or if we want to comment on the shoes or whatever. Jurors are going to do that too. That's not innocence or guilt, especially if you're talking about Shannon Gray's shoes or whatever. But I think the point is we have a conversation about it and it is what it is. We don't make conclusions based on that. We don't say that suit, it makes Brian Koberger makes me know that he's guilty because he has a whatever color suit it is. That's just what guilty people wear. That's what we have to stay away from. I think it's okay to say judge has a cool hairdo, like whatever. We're hanging out here talking about this case. Like we're friends sitting around a table or sitting on a couch, watching this stuff together, discussing this stuff together. Right. I mean, that's okay for some of the discussion. And it's also different here than mainstream media. I'm not telling you what to think. And I think it's okay to be part of the conversation. It just can't be the main part. Like where people were saying with Lori Vallow specifically, how can she put that makeup on knowing what she did to her kids before her trial happened? You know, I think there are layers to this.
You represent potential witnesses that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this: what potential witnesses are we? Number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell them, right? Well, that's free speech. They can say whatever they want to me, and I can go off and say whatever I want that they said. Because it's free speech. It's the First Amendment. So you can't, I mean, this non-discrimination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-discrimination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for your honor. I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, the day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us we can't say anything, we can't say anything, we can't say anything.
So I will tell you, he is definitely letting us behind the curtain a little bit about what the relationship has been like between the prosecutors and investigation and the victims' families. And I'll tell you right now, the state is not going to be happy about this. I don't know what they say, but they are not going to be happy about this. And they're in their head thinking, this is exactly why we need this gag order. This is exactly why we need to shut this guy up, because he's coming out here and just spilling the beans. When in reality, I don't think that it really, I think it's fair game, I guess, in what we're doing here, because either they have information, they're going to be witnesses, or they're not. That's what I think.
We'll get to it. When we wound up nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they never interviewed us. So they're throwing stuff in the air that is not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Good.
Thank you, Mr. Gray. So let me go to the state. I don't know if that's Mr. Thompson or Mr. Ruther.
Don't be me. I want to nominate your honor.
Certainly. Thank you.
If I may,
Yes, you may.
Mr. Rutley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representation.
That usually is followed by somebody lied to you, Judge, or was not honest with you when you say we have a duty to be, to have candor with the court.
As attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading.
Ooh.
And
at best misleading, meaning at worst a flat out lie, right? That's what at best misleading. Words are important. Definitions are important. And the way that he said that phrase, what Mr. Gray said is at best misleading. And if you mislead the court, that's about as bad as you can do as a lawyer.
in many ways, it's simply untrue. I need to correct him for the record. The media is here. I do not want the public to come away with the impression that improprieties occurred. First,
My volume just went down, as I'm sure yours did. We'll do our best with it. Turn it up if you can.
Gray, on behalf of his clients, has propounded a number of questions to our office as the investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation.
Okay, so he said Gray and the family have asked us questions. We've answered them. We can't tell them certain things to compromise the integrity of the investigation.
For him to say that we provided more information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients, and somehow that is the investigators' fault. In fact, from the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it.
So that is a flat out, somebody is lying. Mr. Gray said they've never interviewed my clients, never tried to interview my clients. And Thompson stands up and says, investigators tried to interview his clients and Mr. Gray has blocked it. So if I'm the judge up there, I'm kind of annoyed. I got two lawyers here. Somebody's not telling the truth. Did you try to interview them as witnesses or did you not? Because if they tried to, then they are potential witnesses. If they want to interview them and they want them to potentially be witnesses, then that's fair game. If you've never tried this long into the case, then I'm not going to let you just keep them on the hook or under the trap of the gag order as potential witnesses. So that's a big deal for me.
Just for the record, I want to make sure that's clear. Thank you, Your Honor.
If I can speak to that, Your Honor.
You'll be able to come back in after you hear the other.
Okay, so Shannon Gray is rip-roaring ready to go. He wants to respond immediately. The judge is like, wait your turn. You just were up here for 32 minutes. Let somebody else go.
Thank you.
Mr. Levin, go ahead.
Thank you, Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial.
Oh my gosh, you know what? I just got a flashback of, so I have not watched this. From the back and even looking and listening to him, it sounds like Gwyneth Paltrow's lawyer and kind of looks like him from the back, doesn't it?
Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case.
So he's saying there's a difference from like the media talking about this case and the prosecutor. I think that's fair game. I mean, I think that's true. I think that's fair. But I also think that a juror could say, I can disregard what this person said just as much as I can disregard what that person said. And either they're telling the truth or they're not. And you can't guarantee that one way or the other. That's part of what's difficult about jury selection.
Gentile versus State Bar of Nevada. That case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Gray's repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by.
Okay, so I mean, this is just as clear as day. Gray and the victims' families and the prosecutors are adverse in this situation. I mean, this is unusual, but I think people are seeing prosecutors are not always, they're representing victims, and sometimes it can get difficult and sometimes the waters can get muddy. And that's why I think it is important for them to have lawyers in this situation. But I mean, they're calling out Shannon Gray. They are calling him out. This is not going to be friendly, I don't think. And we'll see how this affects the case. Hopefully it does not affect the prosecution of it or any potential jurors that are mad at the prosecutors for not caring about the victims more or vice versa.
In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonzalez families are potential witnesses in a trial, or more specifically at sentencing. The order in this case is not vague, overbroad, unduly restrictive,
or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so.
So he's saying change of venue wouldn't even really help here.
Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepherd, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most, tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. With that, I'll stand for questions.
Thank you, Mr. Redley. Do you think that would be helpful to just, and I asked Mr. Gray this the same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
Right. Can you go back? You mentioned this about the standard particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up here, that the
Totally fair. I don't want to mess this up. I'm going to actually look at what the case says. Totally fair.
speech of lawyers may be regulated under a less demanding standard.
And Susan, if this was an option and it was one or the other, I would absolutely agree with you. I'd rather have cameras there and the gag order than vice versa. I think vice versa could be bad. Getting rid of the gag order, letting people report on all sorts of crap and give leaks to whoever they want to give leaks to, however they want to give leaks to, and however they want to angle it or use it, but no cameras in the courtroom. And then we're just kind of left in the dark to have to believe secondhand information. That would be the worst. Maria, they can do whatever they want. They can do it like Stalk, where it's weird and you don't feel like you're there, but you can still watch and listen. They can do it like Paltrow. They can do it, like Johnny Depp, where it was like almost like a full production. They can do whatever they want, however they want to set up the cameras. It's just up to the judge on what he thinks is fair to protect Sixth Amendment rights and First Amendment rights on both sides here.
So we would argue that so long as the court finds that it has a duty under Shepherd to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that pretrial, that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Judge, I think a lot has already been said, and obviously we wrote a lot in the briefing, so I guess I'll just touch on a couple of things.
This is one of the defense lawyers now.
In terms of the argument that the victims' families are not involved in the litigation of this case, and if we're going to follow 3.6, would be our position
that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is you have literal rights that permit you certain things that are involved in this case. You're involved in litigation, and therefore you follow 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of his afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just they fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client. We also agree that at this point, the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here where we all get a chance to speak and the media gets all that information. If they still choose to do what it is they've been doing, then that's on them.
So he says, we need to keep this gag order in place. If they want to get statements, they want to see what's happening, it can happen here where everybody can see it. The media can do their thing. But he also, after in the second hearing, argues we don't need cameras. We need cameras to be out, which again is just continuing to restrict what the public access is and the First Amendment. I think all of that's important. Now, media can still come, sit in the courtroom and have an open courtroom, or maybe they'll do audio or something like they did with Lori Vallow, but it's just interesting to use arguments when they work for you.
But we don't have somebody who's trying to put the media into a frenzy and send this case to the firing squad of others. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury today is because there's an old arcane rule that says,
Ooh, hold on. We're going to get the actual reason. So the judge kind of started us off with that, but now we're going to get the actual reason from the defense attorney why he stood silent.
that if you have a grand jury indictment with grand jury indictments, it's because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen a prosecutor use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear.
So they just did it so that they were not agreeing to the validity of the grand jury. And if they want to challenge something in the future, they can. So here's the only way I will disagree with him. I am positive you can still do that even when you do plead not guilty. But not to say a prosecutor would argue that you couldn't. So there you go. There's your answer. Had nothing to do with cameras, nothing to do with media. It only had to do with not agreeing to the validity of the grand jury indictment. Boom. There's our answer. And that's why cameras in the courtroom are so great. Look at this. They can clarify things for us. The judges answered our questions. The defense attorneys answering our questions. Gonsalves family attorneys answering our questions. State attorneys answering our questions. There you go. This is a public trial in the public forum where we can learn what we don't need to read into anything else. I promise you, if there were no cameras in the courtroom and there's a gag order and somebody reported that he stood silent, the media would have run rampant with that. But with the cameras in the courtroom, we got to hear it straight from the horse's mouth. It had nothing to do with that.
Does the court have any questions for me?
I don't think so, but thank you for that additional education.
Thank you.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel expressed.
He's definitely going to respond to Thompson.
I guess the first thing I would want to address is the prosecution's idea that I don't allow our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred. And they still have made no contact as far as investigating and interviewing the victim's families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is everyone is quoting the Gentile case. The Gentile case
They're both basically saying the other person is not being honest with the court.
is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts None of it applies to me
It seems like you're in court right now.
because you're the one that brought me here because of the
You
non-dissemination order.
brought yourself.
Yeah, well,
You're the one who filed the motion.
I did follow the motion because
Oh, this is pretty. You're getting a lot out of this hearing. Okay. Getting some bang for your buck in this hearing. He's like, well, you're here right now. And he's like, well, you let me be here. It's like, oh, you filed the motion. You are the reason you are here, not me. Trust me, my friend. And he's right. He's right and wrong, right? There are only certain things that Shannon Gray has standing to do and is allowed to do. And it is not because he's a party. It's not because he's a witness in the case. If he was a witness, he could file motions for protective orders, things like that. But so it's kind of like this is the gray area. This is the gray area that we are talking about here, that judges have discretions to make calls. That's what's going to happen in this case. Whichever way he goes, it will be an appropriate decision. I will just tell you that there's not one right answer to this question. There's not one right solution to this problem. And I think that's really, really important.
the non-dissemination order is unconstitutional.
Just try to clarify what you just said.
Well, this will probably be the only time I'm allowed because I won't have the authority to file any other motions on anything else in this case.
Why
Because,
would you say that?
well,
He's
because
wrong
I'm not a
there.
party to the case.
He's wrong. He could file a motion protective order for his clients if they do ask to interview them. He can still file motions in the case. He can't subpoena. He can't take depositions, things like that. But there are still other things he can do.
You can still, the media is not a party of the case either.
Once again,
But
they're not-
well, the Supreme Court has said they have standing to come into the court and address issues. So,
yeah, but that's completely separate. They're not.
well, I know it's separate.
Okay, so
I also respect your position in representing the family's victim's family, and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
and the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention of it.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. I had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me that would hold me to it, but I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case.
Not a bad point. They had an opportunity to contact them prior to them hiring him. But that was literally within weeks of this happening. That's tough. Just everything that was going on there was tough, and the investigation was going on. And so I can see that from both sides as well.
And since then, every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this, in the meetings that I have had with the prosecution's office, I have asked, as part of that, whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way, and they've never taken us up. And maybe a random email here and there.
It sounds like a little wishy-washy. He's like, we've reached out to them and we've got nothing. Well, maybe a random email sounds a little less strong, I'll say, than it did earlier. It sounds like maybe there have been some discussions, but not to the level that the victims' families wanted them to be or would like them to be, especially with the information that would, his answer is a little dodgy. I think it's a little dodgy here, not as strong as it was earlier on.
Says something and no follow-up whatsoever about it. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, I people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, our deputy. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
That order was a stipulation.
So he's not wrong that it was kind of like the state, the investigators, law enforcement side that was doing a lot of these interviews, disseminating a lot of this information. And then now they're trying to block him from doing it. I think one of the issues with that is I feel confident the defense wanted the gag order. I feel confident the defense wanted to stop things from leaking because, you know, everybody was convicting him in the court of public opinion, things like that. But Nicole, I saw your question. I am going to answer, but I wanted to wait till the end, give the judge the whole hearing before I know, but we'll still talk about it a little bit. And I know when you asked it. But I think it is important that when we go through this process, we understand that the defense wanted the gag order. The state stipulated to it. They agreed to it. They stopped giving interviews. Basically, the defense asked them to stop giving interviews, voiced their concerns. The state did the right thing, obliged. And there was some collateral damage. And Shannon Gray and the victim's family lawyers were kind of caught under that collateral damage. The media now is caught into it, maybe purposely, and they're fighting back. But I think ultimately the state didn't do anything wrong. Didn't violate anything by giving those interviews. But once the non-dissemination order was in effect and they agreed to it and stipulated to it, that all stopped.
The state and Mr. Koberger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that was stipulated by all parties. I never stipulated to that. I emailed the
You're not
judge.
a party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties. So
So,
you correctly stated who the parties are.
so we would
I
ask,
agree, but you,
The smirk says a lot from the judge. It's almost like you should know the answer to this, Mr. Gray.
you were suggesting that it was entered to shut down the prosecutor's office.
why would they
That's what
claim?
you just said.
I do think that that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
When you say they, you mean the prosecutor's
Yes.
office.
Yes.
All right.
Do you want me to give you a final, or do you?
Go fight
Okay,
it. You go.
We're not a party to the case. You are very aware of that. I have the right to repeat what my clients say to the media. I also have an independent right governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule of the Idaho Rules of Professional Conduct, because I'm not litigating it or part of the litigation. And the reason those things are in place are because people that have real privy information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply to them. Thank you.
Thank you, Mr. Green. All right, well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today. And I'll get back to work and try to get a decision out as soon as possible. So anything else we need to address before I adjourn? Mr. Thompson? Ms. Haley? Mark? Anything else?
We thought you'd probably want to issue an order. Wait, I guess we're just wondering if in the meantime, the order as it is remains in place.
Yes.
Of course.
It remains in place until I address it. So with that, we are adjourned. Thank you all.
All right. So that is the hearing. I'm going to answer a couple questions and give it just a couple comments and overall thoughts there. We'll save that one. So Nicole, what is your opinion of this judge? I don't mind a little snark from a judge. It can be frustrating when you're the lawyer on the other end of it, but usually you can understand why it's coming. What I like about him and what's most important for a judge is he's prepared. I feel like he's read all the briefings and the cases and case law and rules and statutes that are affected here. I think he's going to make a decision. I think he's going to stick with that. And I think he's going to confidently make decisions throughout the case, which I think is the most important thing for the judge. So overall, I like this judge so far. Falcon Quest. Don't you want to err on the side of constitutional rights? Absolutely always. Not just err on the side. You have to go with them. The issue here is there are competing constitutional rights. The First Amendment right, freedom of the press, freedom of speech, and the Sixth Amendment right to a fair trial that are competing. The judge is going to have to weigh that, balance it, and make the decision. Nicole, no, I didn't mean it like that. Sorry, Peter. I had no idea this judge would speak right after I asked. Got a little spicy. No, it's good. I mean, I think the question is fair. And I want to talk about it anyway. So I love when a plan comes together. So thank you for that. And I also want to quickly talk about the alibi extension, Brooklyn basement, significance of BK's alibi extension request. So I hear people saying, oh, if you have an alibi, you don't need an extension. You should know where you were the day and time that this happened, and you should have this to corroborate it and blah, blah, blah. Fine, fair. You can make that argument. But you don't just get to say, I was in bed sleeping, or I was here, I was at my mom's house, or whatever you're going to say. That's not just how it works. You have to also provide witnesses who can corroborate, other evidence you have to corroborate it. So sometimes you can say, I know I was here during this alibi, but it's like, okay, well, let's get security camera footage. Let's get keypad when you logged in or swiped your key card. Let's get your mom or your dad or whoever was a witness, your friend or the security guard at the building you live at. We got to get all their names, get all their information. And sometimes that can take time. So it's not just as simple as saying, I wasn't there, it wasn't me, here's my alibi. You have to provide all the backup documentation with your alibi as well, which again, we talked about with the Lori Vallow case. If you want to go back and listen or look at her notice of alibi, again, it explains a lot more than I wasn't there. And so that's why sometimes you need an extension to continue to gather that information or gather more information. Or you as the defendant might say, I should be able to show because I was on Facebook or TikTok at that point. So isn't it pinging where I was? Whatever information it might be. I'm not saying he has any of that, but that's one of the reasons why you can still ask for an extension, because you're gathering the supporting documentation, which is not unusual at all. Thank you, Azam, for this super sticker, which will give us our transition on the way out. 4,000 people joined us concurrently live here, which is so cool. Hopefully you guys hit that like button. Let's get it up to 4,000 likes before you sign off, and subscribe. Don't forget to subscribe. We're pumped about stuff that's happening. We're rolling out a totally new membership kind of grouping starting July 1st. So I appreciate everybody that joined me today on this Saturday morning stream. Very unusual for us, but I'm pumped you all were here. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.